the NewsChannel 5 network. This is Open Line.
Hey everybody, Rory Johnston with you here on Open Line on NewsChannel 5 Plus. It is a Wednesday night, filling in for Ben Hall. Good to be with you. And tonight we have a very current topic to discuss, and our guest is a familiar face, frequent guest here, Chris Sanders, the Executive Director of the Tennessee Equality Project. Good to see you, sir.
Thanks
you for coming on. So this just happened yesterday. We are talking about a Supreme Court decision. You know, with these Supreme Court decisions too, sometimes they have very broad implications, and reading over the details of this one's a little more interesting, what Justice Anthony Kennedy said. And this is the Supreme Court case involving a baker in Colorado who turned away a gay couple. Two men came in who were getting married and wanted to have a reception in Colorado, wanted to have a cake made, and the baker cited his religious beliefs and said no. So this worked its way through the courts, the Colorado Civil Rights Commission. The Supreme Court ruled in favor of the Colorado baker. Were you surprised by this decision?
When we were prepping for how the case could go, you know, we were working with a lot of national organizations and legal experts, and they gave us about 6 scenarios of the way the case could go. So they did indicate that it could be decided on narrow grounds, and this one really was. What the court looked at was the way the Colorado Civil Rights Commission treated the issue of religion and the baker's religion in their hearing. And what they said was, government must always give people an impartial hearing, and religion must be treated neutrally. It cannot be treated with hostility. And they found that religion was treated with hostility in this case. And so they awarded the decision to the baker without overturning Colorado's civil rights law.
So it was a really interesting kind of a juggling act. And by the way, of course, everybody, the phones are open. This is, for some people, a very controversial topic. You know, freedom of speech and religion versus gay rights. And we're going to go into that, different Supreme Court opinions tonight with Chris. 737+ is the phone number. We hope you will call in. Wide open phone lines. We'd love to hear your opinion, your respectful opinion, as always. We do appreciate it. This particular case was Masterpiece Cakeshop versus the Colorado Civil Rights Commission. Mr. Phillips, who owned the bakery, turned down the couple, saying he would not use his talents to convey a message of support for same-sex marriage at odds with his religious faith. So, so that's what it is. I'm going to read just a little bit of what the New York Times said, and then in a minute we have a piece, I believe, from CBS News from their broadcast yesterday, also giving us kind of a summary of this case and the decision, so that you at home will have a better idea in case you missed this or had maybe just heard little bits. This will give you a little more information. The decision was narrow, as Chris mentioned. It left open the larger question of whether a business can discriminate against gay men and lesbians based on rights protected by the First Amendment. And the key person here on the court, and he tends to be a key person based on the balance, political balance of the court, Justice Anthony Kennedy. He had the majority opinion. It really surprised me too, Chris, at some of the way the justices broke down. It was a 7-2 vote. The only dissenters, Sonia Sotomayor and Ruth Bader Ginsburg, in this. But Justice Kennedy, basically, he turned on the argument here. From what we understand, when this first, the case has to be argued to even appear before the Supreme Court. 4 of the justices have to say, okay, we will hear the case. And from what I'm reading here is Justice Kennedy didn't want to hear the case in the first place because he has been such a strong advocate of both of these issues. And he was really looking for some other option. Is there some other option here? Because he really has strongly reaffirmed, we should point this out, has strongly reaffirmed protections for gay rights. which I would think gay rights advocates such as yourself and others feel pretty good about that, despite the outcome of this particular case.
Right.
And basically, the majority opinion, I'm going to read this again from the New York Times, turned on the argument that the Colorado Civil Rights Commission, which originally ruled against the baker, had been shown to be, as you had mentioned, hostile to religion because of the remarks of one of its members. And what's funny is later on, interesting I should say, later on Justice Ginsburg, who dissented, basically said a few stray remarks were not enough to justify a ruling in his favor. What prejudice infected the determination, she writes. So were you prepared for Justice Kennedy to kind of take this off-ramp, as we call it, looking for a choice here?
Well, again, we thought it might be narrow. I did not conceive that he might go this particular route. And I should note, I have a Master of Divinity. I don't have a JD. I'm not a lawyer. But I think what he did was, as you noted, he says that he's trying to hold two things in tension. And he says, in his opinion at the end, the outcome of cases like this and other circumstances must await further elaboration in the courts, all in the context of recognizing that these disputes must be resolved with tolerance, without undue respect to sincere religious beliefs, and without subjecting gay persons to indignities when they seek goods and services in an open market.
Okay.
So, as you noted, he's struggling there, and he thinks it's going to take more cases coming up through the courts to draw some lines, and they're just not ready to draw the lines yet.
Right. 737+ is the phone number if you'd like to call in. We want to know what is your opinion. And of course, this goes back. We're also going to talk about what happened in June. Boy, it's almost 3 years now.
Right.
Is it Obergefell versus Hodges, which was the landmark civil rights case?
Sure.
That basically made same-sex marriage legal across the United States, basically saying that they are gay couples, same-sex couples are protected by both the Due Process Clause and the Equal Protection Clause of the 14th Amendment.
Right, and on that, it's interesting to compare the two cases.
Right.
People ask me, well, Justice Kennedy was so helpful on that case, what happened here? And there's an important distinction. In the marriage case, the Obergefell case in 2015, the justices were dealing with the question of what the state can do. And the states are restrained by the 14th Amendment to the Constitution. They must make their laws with a view to equal protection. And if the state is treating people differently, well, it's not allowed to do that.
Right.
In this situation, we're dealing with state laws about private entities. So you're going to have a different set of considerations there.
Right.
You're going to be dealing with a statute and whether that statute is fairly applied. And I think that's where you see the difference, the breakdown. If you want to say contrast, that's where you would see that. It's really dealing with two different sets of considerations.
I'm going to go on and read a little bit more here from the New York Times. You had just wrote this. The outcome of cases like this and other circumstances must await further elaboration in the courts. All in the context, I think you just read that exact thing, didn't you?
I did. It's at the very end of Justice Kennedy's
Justice
opinion.
Kennedy, they say, often casts the deciding vote in closely divided cases on major social issues, which we talked about. We know that. When the court agreed to hear the Colorado case last June, it seemed to present him with a stark choice between two of his core commitments. On the one hand, he has written every major Supreme Court decision protecting gay men and lesbians. On the other hand, he is the court's most ardent defender of free speech. So on Monday, it says Justice Kennedy chose a third path, one that seemed to apply only to the case before the court.
Right.
And there was some specific language there where he wrote basically saying, this is just this one case and here's why.
Right. That's right. So again, the implication, people are asking, well, what does it mean? The Colorado civil rights law is still in place, as we've said. There is no national business license to discriminate. All Also, though, the question of to what extent religious liberty can be claimed as an exemption from civil rights laws is left unresolved as well.
Right.
And in addition to that, you have a huge group of states, Tennessee is one of them, that doesn't include sexual orientation and gender identity in the Tennessee Human Rights Act. So in Tennessee, we can be turned away from businesses right now.
All right, we're going to take, you want to take a quick break here, Taylor? Let's go ahead and take our break. We've got a couple of calls coming in. Callers, hold on there. When we come back from the break, I'll introduce the CBS News piece so we have a better full picture here of what we're talking about. We will start to take your calls. Hopefully we'll still be on Facebook Live if I can figure out this iPad and get it working. We'll be right back on Open Line after this.